or concerned about their firms or organizations being labeled as dominant, including in the past as Safaricom. My understanding is that dominant is just a legal term that signifies that a company has met a certain threshold when it comes to, say, market share or certain market power. But unfortunately, our concern is always trying to, fend off that tag as being labeled dominant. But dominant doesn't necessarily equate to, say, abuse of market power or suppression of competition. So maybe I think one of the things we need to do in this policy is that there needs to be a clear threshold, if it can be put there, so that then we don't expend so much energy on are you dominant or are you not dominant. But then you could be a dominant, but you're operating benignly. Or when somebody looks at how your market behavior, it's not you're not trying to suppress or block competition from especially from smaller companies coming up. So I think that's just a concern that I've noted.
Thank you very much, competition. Based on that, I think over my years I haven't gotten somebody who really broke it down that well. So then you really are able to actually focus on the dominance question across the horizontal and the vertical. Prof. Asante Sana, I must read that paper of yours. Back to my panelists. Who wants to take one of those questions? I was actually very interested by my sister at the back end when she talked about the Hakikisha component. And I think that is an interesting conversation around platforms and ecosystems. And it could have an impact on this bill that we are talking about, because you're now talking about transcending from one platform to another, to other platforms, because one player has become so dominant, and in this case actually in a positive way, that guys are starting to ask, can we have the same sort of service that we have on this platform that transcends to these other platforms to protect consumers? I think Prof would love that here. Stella, would you like to make a comment on that? I need the mic here.
Okay, yeah, that's a very interesting take, and also question in terms of how exactly Hakikisha works, and just the place of sometimes out of innovation you find yourself being a critical infrastructure in terms of just accessibility to various other platforms, which I believe is one of the questions that the lady was asking. And one of the things, just in line with the conversation we are having here and also the regulation that is being passed, is for that forethought for our regulators to have. In terms of if we are trying to pass a law that speaks about superior bargaining position or even the place of platforms, are we really looking at the situation on the ground? What is actually happening? Is there a problem? And if there is a problem, one as has been highlighted there, what are we doing to actually try and resolve the problem? So one of the things, and maybe this is preemptive, not speaking on behalf of Safaricom here, just my opinion, M-Pesa is regulated under the NPS Act. Banks are under the Banking Act, which is quite different. Much as we have the same regulator, some of those conversations around interoperability always happen within the mobile money space and the PSP. So are we interoperating with Airtel, for instance, or T-Cash and all that, right? But when it comes to banking, there are certain other things that banks require that we don't, based on the regulations that we have. There's also the principle of finality of payment, which then comes, it's addressed in the NPS Act, not particularly addressed in the Banking Act. So it becomes a bit of a challenge for...
Sorry to interject here.
Yes, yes.
You know, when you... Sorry to interject here, but when you make such an important point, like the principle of the finality of payment, some of us just floated for 1 minute there. Just step back a bit and explain it to us and then move forward, because I think that's a very important question that most of us sometimes don't understand, and we end up blaming parties that have nothing to do with it. Back to you.
Okay, thank you. And I'm happy to explain the principle of finality of payment. So ideally what that principle says is as soon as money moves from your hand to another person's hand in terms of payment for services or goods that have been provided, then you lose title over that money. It moves from me, Stella, who is paying for a service, to say a bank, or it could be even my mama Boga. As soon as I've made the payment and it has reached her, then I've lost title over that. So exactly what we're saying is the payment is final. The money belongs to the person who's received the money. So that is a principle that operates in actually banking and payments, right? And now here we come, comes a situation where you say, I've sent it to the wrong person. M-Pesa is just a platform that is providing you that operability for you to be able to move money from myself to, say, the service provider or even my mother or whoever I was sending the money to. Safaricom does not know if indeed you intended to send money to that person or there was an error. So that is why with Hakikisha, what
you mean AI can solve that?
We cannot know. You see, majority of the time is this. You are either at someone's shop trying to make payment for something. It's a physical interaction. M-Pesa only comes in at the point where you're making the payment, right? It could also be, we've also seen with the OTPs, OTKs, you were trying to pay for something on a different platform, right? You entered a phone number, sometimes even confused. Maybe you put in a 0 instead of a 1 or whatever it is. The OTK goes to someone else. They were not paying attention, they make the payment. We do not have as Safaricom, even as an independent person, if two people came to tell you, I got money, I sent money to this person, you would not be able to determine whether or not indeed that person was the intended recipient of the money. So it puts us in a vicarious position. So how we handle that is we will freeze the funds, yes. As soon as they have moved to that, you have complained and said, okay, I intended to send it to someone else and then to this person it was wrong. Then we will ask the recipient of the money if indeed we can proceed with the reversal. If they refuse, then we really cannot intervene. It becomes a criminal case. You can also pursue it as a civil case, and it's provided for under the Computer and Cybercrime Misuse Act. And if the person then consents to have the money reversed, we can. Because in that case, we have certainty from both parties that indeed the monies were actually, there was an error at the sending of the money. So that just to appreciate how that ends up working. Thank you.
Spot on, Stella, spot on. Peter, you can go very quickly.
Yeah. You
want to say something? Yes.
Some of the things you're talking about here are the things that I started by mentioning. The regulation is a bit too early to talk about dominance, especially on online things like food delivery. But it is not too early to talk about consumer protection.
Spot on.
Quality of service. Let me give an example. This will connect to this. So when we were running OLX, which is today GU, one of the biggest challenge was always fraud. I saw a laptop on your platform, I contacted the person, they gave me the laptop, they showed me, I paid them, then they fled with the laptop, or vice versa. And the person will come because they know they now talk to OLX, and I think yesterday we saw a case in the Business Daily of a manufacturer from India who is suing one of the platforms for counterfeit goods on their platform. Now, these are things that would prevent platforms from growth, because the minute there is no trust between the buy side and the supply side, then you stunt the growth. So I think the regulation, if so far interested in the growth of platform business models, that is where we start. Regulating around quality of service, counterfeit goods, consumer protection, that's a very great place to start.
That is from a practitioner on the ground. as I like to say, Vitukwa. Yes, Prof, you can say something and then I'll come to Priscilla. There you go.
I like his statement. One of the things I want to truly emphasize is that under the Consumer Protection Act, it is covered. It is fully covered. All the digital platforms that you talk about, the supply of fake goods and so on, they are comprehensively covered under the Act. So even as we are trying to put new laws, we should be asking ourselves, is there a law already existing? You understand? So that is why I was saying, it is one of the problems we are having is that the laws which are already existing are not being utilized by the regulators, enforced properly, so that we do not need to bring in new costs on companies. And you had the lady here highlighting the costs and the processes that we talk about, but enforcing the existing consumer protection laws. Are we even, do we even know about them? We don't seem to know about them. All right?
Prof, thank you so much. Priscilla, you want to say something? And I'm cognizant of the fact that we have a 1 o'clock hard stop. So we're going to wrap it up very quickly. Priscilla.
So I don't have to repeat what has been said.
Yes.
So just to agree, especially around building digital trust first. As you come up with this innovation, the consumer needs to be able to use the platform. So that's something very important, and I agree with Peter. So probably what I could talk about is what you started with in terms of success and dominance, right? So I think if we look at the lessons from M-Pesa, they are interoperable. Is that the right word? Interoperability. Yes. So the reason why they're dominant is because they're working with others. So maybe what we can learn as businesses is to make sure we institute, or rather institutionalize interoperability from the get-go. So allow your systems to also work with others. For example, MyDAO right now, what you're trying to do is to make sure if you have a smart card, you can come to MyDAO, use MyDAO, and then we claim for the insurance. Same thing. If you have insurance, we can do that right now. Payments, we have M-Pesa, we have Airtel, we have all sorts of payments. So making your system interoperable.
Open. Let's say open.
Making it, if you're able to collaborate with others, you can now become dominant, and it should not be seen as competition. And like also Peter said, around we are too early to start talking about dominance.
Thank you so much. I wish we had more time, but we don't. So I want to close this with a question for all of us, and then I'll take one question or comment from the audience, and we close it. Yes, I'll come to you, sir. Regulation, coordination, and enforcement. Ladies and gentlemen, I'm here to tell you today, operating in Kenya is an extreme sport as a business, as an entrepreneur. If I ask Safaricom, for example, or Peter, my good friend at the far end, or Priscilla, or even Prof here, some platforms, digital platforms, do you know how many regulators you have? Let's start with the first one, Rosemary. Telco regulator, which is the Communications Authority. The next one.
Bank. Central Bank.
Central Bank of Kenya. The next one. Competition Authority. The next one. IRA. The next one.
Treasury. Depends.
For her, the pharmacy board. The next one. ODPC. Tumesahau ODPC. Kanjo. Now, guys, how can we avoid what I would like to call regulatory fragmentation? Or forum shopping by powerful platforms? What steps can we take within this bill that can clarify some of these things? And let me tell you guys one thing. As Kenyans, we think just because we invented M-Pesa, we can sit back. Yeah? Other countries are actually going well ahead of us. Yeah? Nigeria has the open finance platform, regulation and policy, which is starting to work extremely well. They've just announced a one-stop shop for FinTech regulation. 1 minute from Peter coming this way. How do we avoid this thing? How do we engage? How do we have a seat at the table to ensure that we are listened to?
Yeah, I think three things are these. So the first one, and I think we didn't talk also about KRA, are we taxing gross merchandise value, or are we taxing commissions?
That is a whole different forum.
That's right. So what I found, because I think we've done a few pieces of education to regulators and enforcers, is just very good education, which means, as Priscilla said, sitting in a room together as we're doing. And for the state side or the regulator side to actually listen to what are the different business models and operating models that actually are running, and what is the economic model for that particular business. And then I think that helps in creation of the one-stop shops, because you start to see what regulation, what side does this regulatory party need to go through. For example, why should I be going to IPRA, going to Kanjo, going to, so I think first by the state's understanding and having a very good education on all the incoming types of business models. You can't be able to innovate your way as a nation if the people who regulate and the people who enforce don't understand the innovators and what they're trying to build.
And the nuances around us.
And the nuances around.
Peter, thank you very much. Stella.
Thank you. I think, Peter, I agree with you. Just for regulators to be open to explainability, allow us to explain what it is that we want to do, and then regulate if you have to. And for me, there's something else that was mentioned in the first panel as well, in terms of the more memorandums of understanding that different regulators have. And I think one thing that needs to be very pertinent to those memoranda of understanding is for us to actually know what they are and who are working together. Because that's also a challenge you're having with consumers complaining to you, they'll complain to CA, to CBK. You have so many regulators looking into the same thing, yet they have a memorandum of understanding that no one knows about. It should be clear what exactly, who is handling what, and if you've agreed and there's a lead in a certain area, let the public know so that it's clear who is handling what. Thank you.
Thank you, Stella. Priscilla?
Yes, so I do agree that, okay, if I look at my DAO right now, the number of regulators that we are involved in are quite many, because we also have telehealth platforms, so KPDC is also one of our regulators. So I don't know if there's an opportunity to create like a digital economy council that kind of does the capacity building, especially for businesses, knowing who you need to know where etc. and then provide that guidance. I don't know if it's that opportunity. The other thing I would like to talk about is how do you work with the regulators to provide data to enhance their, the laws. I can give you a good example. Right now, we are working on a project with the Gates Foundation around the delivery of PEP and PrEP medication. That's the HIV prevention medication. So we've done that for 2 years. We've collected data, and we've seen it's actually a good way of delivering the medication. So what we are waiting for is for the regulator to allow us to do that as a standard of care. Because currently you cannot be doing that. It's only by now because we are being allowed to do research. So how can we do more projects around the same? We probably work with a public university to collect the data, etc. Design a study so that that data can be used to influence policy. So maybe that's an opportunity as well to work together with the regulators.
Thank you so much.
Thank you so much. You have brought up some two things. The first one is the issue that O'Malley highlighted. The number of competition they have with different regulators, all trying to protect their own tasks. So the first thing that comes in mind is that in Kenya, we somehow subjected the Attorney General's office to a lower level. Instead of him or her being the DOJ of Kenya, the Department of Justice, to ensure that some of these issues that come up are handled by one body up there, the one that I think it was you who suggested something that is higher up than the regulatory bodies. The second one that people need to really understand is that in the olden system, the regulators were not prostitutes, they were part of the ministry, and therefore there was no cost directly to the people. What has happened now, regulators also make money out of paying. So now it is commercial for them, and therefore it is so difficult to now work with them. So to me, my suggestion is this, Sure. I think we need to think of sponsoring a bill that tries to change the way regulation is done in Kenya, that enable us to combine these things in a way that one, costs are taken back to the ministry from the taxes we pay, so that they do not get themselves interested in making money out of regulation, but providing the services for which they were supposed to do. But it is going to be very difficult. All right? But to me, that can actually work if we start thinking in that way.
So, Prof, you're just being polite. Some of us just call it rent seeking. Simple. Guys, thank you so much. I can see Gigi looking at me like this. Amaliza. So we have to close it, but as I promised, I want to give one person on the floor to say something, then I close it. Who wants to come and get the mic? I've already identified somebody who's been on my case since we started. Please introduce yourself and start.
It's not on our side. I'll introduce myself, Innocent Kubebea, CEO and founder of Tusome Digital Academy. Well, sticking to the point of today, it was about the roundtable about competition. So that is the point. I'm very glad people take ages to meet. Maina was my neighbor some years ago, Prof. And I would suggest for KICTANet and for those of us who will be in touch with him, you have to take a very strong lead in terms of that bill, the review, because as Prof rightly put it, the consumer is a key stakeholder in the whole story about the competition bill. My next and last point, thanks to Dr. Gidaida, who apparently is also my church fellow member, for telling us about Safaricom. We really look forward to that day. And for my sister Stella, I think Waidera just took a bit of a long time, but Safaricom should be watchful. I know people here, some of us follow X and all that. There's so many complaints, especially money going to a bank, maybe by mistake, they never refund it. So just be aware of that. Otherwise, thank you so much.
Asante sana. Thank you very much. I would like to reluctantly close this panel to say that one thing, as we look at this bill and as we continuously engage, I want to remind everybody to everyone go away with a Swahili saying, mti ulio na matunda ndio utupiwa mawe. So tafakari hayo, as my brother from Citizen would say, and to really emphasize what Peter especially said about ecosystem building, and for all of us to step back and actually go back machinani, beyond what we are doing here, and really understand what is actually being built on the ground before looking at, we are in cloud 9. It's like those guys who talk about cloud computing and they don't know una servers and wires that actually make that cloud computing work. Ladies and gentlemen, asanteni sana for giving us your attention, making contributions, and special thanks to my sisters and brothers on the panel for giving us their attention and their wisdom. Asante sana. Thank you, guys.